This is about codes of conduct. It's not a new topic today. I think Klaus Ulmer, in the opening panel, talked about the need to have codes of conduct and certification and the need for these to move relatively quickly if they're going to be an effective instrument. What we're going to do in this panel is work out, and I'll introduce the panelists very shortly, what are the expectations on the side of the regulators, and we have the European Commission amongst us as well, and what's the experience from an industry point of view. So it's the balance between the two. Also touch on the important role of monitoring. Just very briefly by way of introduction, because no one's going to introduce me if I don't do it myself. I'm from IBM. I lead the cybersecurity and cloud policy area for the whole of Europe, and I've been involved in codes of conduct for quite a time since the Commission launched, under Nelly Kroes launched the cloud strategy in 2013. We have Marie-Therese Ettmeyer from DG Connect, who's head of policy in her area. Ladies first. Lorena Marciano, who's director MIA for Cisco, director of data protection. Maria Wilhelm from Baden-Württemberg, who's the State Commissioner for Data Protection and Freedom of Information. Peter Shaw, needs no introduction, but now the chairman of the European Academy for Freedom of Information and Data Protection. And last but not least, Jörn Wittmann, managing director of Selbstregulierung Informationswirtschaft, proving I can speak a bit of German. Okay, and to kick this off, it's going to be a very interactive discussion also among the panelists. I'm going to start actually with Marie-Therese and just to say what were the Commission's expectations and reasoning when codes of conduct were introduced under GDPR.
Thank you. I would say the main idea was that code of conduct would be a tool, an instrument for businesses to facilitate their demonstration that they are in compliance with the GDPR. We all know, I mean, the idea of a code of conduct is not completely new. That was also already in the previous data protection directive. But the GDPR gave clarity on the content of code of conduct and in the procedures on how to get there. So for me, the main aim of code of conduct is to provide an added value to the GDPR, addressing specific needs of specific sectors and SMEs when they have to process data and addressing in practical terms on how they can apply data protection rules.
And they're an interesting instrument because they're co-regulatory by nature, so it's always interesting to look at, the different options. Peter, you were a DPA at the time when all this was launched. So, what's your expectation?
Yes, as was said, this is not a completely new instrument. The former directive, Data Protection Directive of 1995, also contained one article dealing with COCs, but there are two main innovations, I would say. At first, that those COCs may be used for demonstrate the compliance of processors as well as for controllers. In the former time, this system was focused on the controllers. And the second is that there must be a kind of oversight, independent oversight, integrated in the system of COCs. These are the main innovations from my perspective, and I hope it will work. I know that there are some approaches to get such COCs on the European level approved by the European Data Protection Board. Whether it will be a success story, we don't know until now, but I hope so.
Thank you. Maria, from your point of view, do you think codes of conduct, once approved, can help DPAs as a supervisory authority? And how might they do that?
Yeah, I think that, or an opinion of the EDPB and the supervisory authority code of conduct can improve the level of lawfulness of processing. They can improve the ways or aims of accountability, and we want to try to learn from that process, because it can be really useful in special sectors for special processings, even for like some sectors where we just have micro enterprises who can come together and just make their code of conduct and cover a field with self-regulation or co-regulation instruments that we didn't have our focus on. So we have very high hopes. We want to encourage it. We already provided the guidelines of the EDPB in the code of conduct sector, and we outlined the benefits they have for us as DPAs there, and we want to see this special tool get into force, and just to see how it will develop in the next years.
Thank you very much. And Jörn, I know you've worked on different codes in the past. And not only in data protection. So how do you think co-regulatory tools can assist policy making?
Yeah, actually I think the policymaker nowadays has not much of a choice in many areas, especially in the digital environment, I think. I think it's not, as you said, the only regulation we see right now where codes of conduct are mentioned are actually an effective tool, because we all know the speed of innovation gets higher and higher, and the need for flexible tools is also getting higher. But at the same time, it must be ensured that the democratic, legitimate regulator stays in place and defines the goals. At the same time, it needs to be implementable. So I think from my perspective, the regulator didn't have much of a choice than going for defining goals, defining ways how to reach these goals, but then also adding tools like codes of conduct to help the businesses to actually implement. And I think the way it is done in the GDPR is really well. I would like to add here to what Peter Shah said, because one really important added value of the GDPR compared to the directive when it comes to code of conduct is also that there are now clear incentives for companies to join. Because now there is clearly written in the GDPR that it can be used to prove compliance. That was something you couldn't find in the, under the directive. And I think that's also the reason why, I mean, we work with codes of conduct for many years already, why we now really feel a lift up of the topic and really feel that it's getting adapted on the market.
Thank you. And now I'm going to turn to industry, Pierre and Lorraine. We've been involved, Cisco alongside IBM have been involved for many years now in EU Cloud Code of Conduct. Looking back to the time when you decided that Cisco would join, what were the main reasons, and when you joined, and what dimensions, what is the reaction of customers to an endorsed code? And maybe you touch on the notion of transparency as well.
Yeah, indeed. So indeed, certainly as a company, we were interested in writing a code of conduct, not only because obviously as many companies we want to have a suitable tool to prove compliance to GDPR, but also because we feel that this is an important tool to ease the trust relationship, so the transparency based on what our sector does vis-a-vis our customers and also the customers. And then I think it is really, for me, it has the potential to be really a standard for the industry. And so when you set a standard, then everybody is something that they should look for. And therefore, if you decide that this is the best of the best, then you kind of set, from a competitive and differentiator standpoint, you also set the bar for everybody else to aspire to that level. And the third thing, which I think it's important, is that the code of conduct for many companies, especially like Cisco that works in the B2B market, it's a way to ease the conversation with our customers, because by showing the code of conduct and giving proof that we abide by, it's easy also for them to do their own due diligence. And so, because of the code of conduct obviously needs to show compliance to GDPR, as a result, you also help the customer kind of check the box on their hand as well when they onboard as a vendor, which I think is extremely important. And more generally, I would say it also helps, ease the technical discussion, because I think it's there are customers that are very knowledgeable about cloud or about any type of sectors, but there are others that might be less knowledgeable, especially the implication with privacy. So having something that it's fruitable, you can look it up on internet, you can check it from time to time. I think it ease that discussion, especially if it's very well detailed and well written. And I like also what has been said earlier about the code of conduct being not a new thing. It's true that it's not a new thing, but that's changed a lot. I remember the code of conduct under the directive that were made in a room between public administration. The company were not really invited to give feedback. Well, now it is encouraged that the code of conduct are the result of company get together, survey themselves, understand what we can do together to make sure that obviously we comply with GDPR, but we do even a step further. We implement those legal requirements in something that is tangible and understandable.
And I guess, the fact that it's out there in the public is a public good that people can look at and assess themselves and use to their own advantage. Yeah.
No.
Right. Yes, yeah.
Can I ask a question? Yeah.
Yeah, you can.
Very good. I would like. I'm looking at Peter Schaar and Maria Wilhelm. And in the morning, we heard from Klaus Omer a little bit of criticism that he wishes for a stronger dialogue between DPAs and industry. So especially in this case related to guidelines before they are published, not only performing a public consultation, but work closely together to get something done that can be reflected in the market better. So do you think it's a tool that can be used, so codes of conduct as a tool that can be used to foster the relationship between DPAs and industry, to improve the mutual understanding?
Yeah, so I think that we, it can support both sides with special knowledge about the field, and we can just improve our work if we have that special knowledge and take a look at the code of conduct with that perspective. And I am pretty sure that it's a really good tool just for, or not just for, especially for special processings and special ways for processing, and there you have those special knowledges always involved. And I think we always have to be open, even as supervisory authorities, for new technologies, and we have to just not be restrictive, just to encourage to use those, and but to encourage to use those in a lawful way and a lawful way of processing. So yeah, I think we could all have some benefit out of it.
Well, some additional remarks. Well, I also think that this instrument may improve the dialogue between regulators or DPAs on the one hand and industry on the other, because industry will draft such COC, and then the COC has to be approved by the DPAs on the national or on the international level or European level. And of course, they read the proposal and they have some questions to understand more what is proposed, and sometimes they have doubts whether this is enough. And therefore, they need to get into a dialogue. And I think that happens today. And it happens better than before, because the elements which have to be checked are much more clear than before. So in the former directive, I think there was a sentence, they have to demonstrate the compliance or so with the whole directive. Now there are specific issues that have to be addressed. And of course, specific issues are very specific. Processors have to meet other requirements, for example, as controllers. So I think, yes, it might be a way to improve the dialogue, and this is not only an instrument in the toolbox for the industry, it's also an element, an instrument for the DPAs, because they have a lot of new tasks. They have the old tasks, and now they have much more tasks than before. And now they can stick to the COCs, and if they have approved the COC and the monitoring body was accredited by a DPA, this must be taken as a kind of evidence, an element of trust, even in the relationship between both.
Yeah, I'm just going to turn back to you, because you haven't had enough mic time yet. And whilst we're still on this, what do you think about the sort of international dimension of and codes of conduct are not just European tools? We've noticed in the EU Cloud Code of Conduct that there's interest because GDPR is becoming, whether you want it, it's become a sort of type of gold standard. So some of the highest interest has actually been from outside Europe to start trying to prove competence in data privacy. Is this something that surprised you, or how do you see this development? And this is not scripted, I'm putting you on the spot.
I think the keen interest now that we see from outside of Europe about the high level of data protection we have ensured in Europe came to a surprise to many, if I may say so, following some of the press before even the GDPR applied here in Germany, and what it will ruin, and there will be no business on the market anymore. And so, but what it really shows is that we were right on the spot. It was time for the high level of data protection. We have many cases, some where we see non-compliance with data protection rules. We see that trust is one of the biggest elements needed for any data economy to work, because you need the data of the people, and if they don't trust on how you handle the data. So the main purpose of the GDPR, enabling, empowering the data subject towards that they have how they can that they have actually information on what happens to the data, was the right way forward. Whether now codes of conduct play a role at international level, I mean, what we have already ongoing is the e-commerce rulebook negotiation, 77 countries renegotiating. We have G7, G20, data flows with trust. Japan, Prime Minister Abe made a speech making clear that international data flows is a key instrument. And from the Commission side, it's absolutely clear that data protection is not a tradable asset, and that any kind of international data flows can only happen in complete compliance with the GDPR rules and the high data protection standards we have established.
Thank you.
May I add, the GDPR refers explicitly in Article 46 on COCs. And this is in use, because that means that COCs might be used to demonstrate compliance in the field of data transfers to third countries. And if these COCs provide sufficient safeguards, this might be the basis for data transfer even to third countries without prior approval for the single transfers, so by the DPA. So it will help to improve the data transfer, as well as it provides guarantees for the individuals to exercise their rights.
That's a very good point. I want to move. Sorry.
Just one
Yeah,
thing,
yeah.
because I mean, it's so such a keen interest. We had the adequacy decision also with Japan just at the end of last year. So I mean, all the trade negotiations in the free trade agreements, we have already a set of rules of provision on how to implement also data flows for non-personal data, because of course everybody knows you cannot separate them. So yes, it's really, we are on the brink, and I'm happy to see that actually Europe is giving the standards which are taken up internationally.
Yeah, on
Whether
the brink
it's
is a good, it's
California,
important, yeah.
New York, I mean, it's worldwide. And sorry, now I had my time.
No, I just wanted to add that in the context of third country data transfer, I would even say it's a stronger tool than some tools that are out there if you compare it to standard protection clauses. The model clauses, we have here, as you already mentioned, the monitoring system behind it. So it's something that I think could easier stand the test of any court decision, especially if it has to go through the DPAs and they have to agree on what's happening on that end, which is, as we all know, harder to challenge by a court decision than it is, for example, in the Privacy Shield environment or SECs.
Yeah, good. Well, I'm going to move on to the next topic now, because I know the audience is very keen to understand what experience we have within this group of codes of conduct. And I'm going to start with Maria. From your perspective, have you had any initial experience in your own DPA with code applications? And could you give us an insight into perhaps how many codes are being discussed already within the European Data Protection Board, or some indication, some feeling of where we are?
So unfortunately, for the EDPB, I can't say, or I can't provide you with numbers. We have in our national system, we had some special code of conducts we discussed in the past, but there were not so many. And now on European level, there are some in the pipeline, and we are all very curious about those proceedings and about how the outcome will be and what we can maybe establish with knowledge from that proceedings as maybe best practices in that field, and to just generate some general knowledge about that that area, and just to improve our work in that field. So I'm sorry, no numbers. But
No. But yes, we're all very interested, of course, and I'm not surprised that you couldn't release any specific numbers. But they're on your map, in any case. Yeah.
Only a few words on our experiences. I think the experiences were not very good with these COCs in the past. As was mentioned, there was only one approved by the Article 29 Working Party in the early 2000s, and then no other. There were some tries, but all failed. So, and on the even on the national level in Germany, it was very hard to come to those codes. I remember that we needed, I think, 8 years to come to this national code for the insurance industry, and it was, for me, it was not really successful. At the end, yes, but it was very, very hard work with a lot of involved DPAs and different stages of compromises and so on. And at the end, it was approved by the German DPAs. But now the EDPB has to deal with these new approaches. And I think I see, especially on the field of business-to-business relationships, some good ideas to use this new instrument, because businesses have to demonstrate to other businesses that they comply with the requirements. This is not only the case if there's a processor-controller relationship, but also if, on the Article 26, I think, controller-to-controller relationship. Therefore, we have a lot of such constellations. And for platforms, if they are processors or controllers, it might be very helpful to get some of these sectoral standards. defined by COCs.
Yeah, maybe if I might add, I think what we learned from the past, from those proceedings we had in the past, is that a code of conduct should always be applicable and just mirror like the real situation, and should just be able to enforce in between the company. And what's always very important for the DPAs is like the data subject perspective. Like we have to look for the data subject rights for the provisions of the GDPR, and I think that those are the main points we always have to focus on. But I think it's a chance for the future just to improve those proceedings, and just to use this tool more often in the future.
Yeah, of course, in a B2B scenario, data subject rights are not always easy to define. But Lorena,
I want to just ask you a question then, digging on this. So if you could picture the perfect, let's say, process to get a code that it's been drafted by a coalition, let's say, of companies and presenting to you, what kind of requirements you will look for to make it really successful, something you will actually approve? Because you were mentioning the data subject right. Are you saying that we should do like a survey with data set? So should we consult them? What would be your recommendation, let's say?
Yeah, I think it's a good question, because we are at the beginning of a development, and now we just are looking for best practices and criteria. Not just you, both sides, and I think it's like a process. We just have to go through the first proceedings. We have to see how they will work, which code of conduct or which systems are provided there, and I think we can just see what we can take from those proceedings, and we had to try to provide some guidance with the EDPB guidelines, so there are some criteria for the codes. I know it's a general approach, but it's a point to begin. Yeah, and I think there will be more best practices developing in the future.
Yeah, well, whilst Lorena, I'll follow up just a second with you. Yeah, and I know you're quite eager to take the mic, but I just wanted to ask from an industry perspective, as we've had the DPA perspective, what do you think have been the main, over the years, some of the main challenges and experiences in working together with other cloud providers and molding together a code of conduct which on the one hand industry can agree with, on the other hand is going to be a useful tool for the DPAs?
So indeed, I think it's a process also for us. So indeed, it's a learning process for everybody. I think one of the main, essentially it's time consuming. Jörn was mentioning that we had more than 200 calls in 2 years. He said 200 calls, but every call was like 3 hours. So in hours probably would be even a bigger effort. Or even more. So it is time consuming, and it's not because we disagree with each other. Actually, no, we actually agree very much with each other. That's probably because we're part of the same industry, and naturally we have the same type of challenges. And the same way we have the goodwill to put in place something that it's valuable to put out there in the market, for a simple reason, because if we come up with something that it's not suitable or it's not understandable, we're not so much concerned about you, the DPAs, we're also concerned about our customer that certainly will not trust us more. So there is no point. So in getting something that it's not understandable, that it's not clear, that it's not serious, it's just we're wasting our time. So I think it was a very collaborative environment. The challenge is to go a step further, because it's not sufficient, at least in our experience, just to rewrite the GDPR. That's not the added value that it's indicated under the GDPR. It's actually to go a step further and see, okay, taking that's the requirement, how do we implement it in practice? It can be as simple as discussing how to process the notice for new sub-processors, or how to make sure that our customer will have our cooperation in data subject request, or so how do you strike the right balance, and at the same time you give the process out there, which will be a guidance for us, but also for all the company that will come after us, and we will need to adhere to the code. So it's really thinking in very practical terms. It's also thinking about what's already out there that we can aspire to. So from a security perspective, what we can already have, that we have collectively as a company, that we can just implement it further in the code. So looking at the major certification and understand that many of us had the same, that also helped us a lot. Because if one of us would not have all certain certification, that certainly would not helped with the conversation. And then another point that's very, very important is also how do we take care of companies that are not the same size? So there are small and medium enterprises in our consortium, let's say. How do we make sure that what is feasible for us is also feasible for them? Because indeed, and that's where the guidance, that's why the code is important, but also developing accompanying guidance, developing different alternatives for different sizes of company. It's important. Obviously, as a company, we have much more resources than a smaller one. So if we do a process that's very complicated, maybe for the small and medium enterprise, it would be just unfeasible. And it was mentioned, I think, this morning about competition law. That's where this code of conduct become a power ally also for company of smaller sizes to actually enter in a market. So if we set a boundary that it's a bar that's too high or it's too complicated, then we're not helping others to actually being able to show compliance with GDPR. So it's quite of a complicated exercise. My experience up until now, and from my colleagues from all the other companies, has been great cooperation. But indeed, it's very long time consuming. It takes a lot of consulting, indeed, that we have done with different types of sizes. Maybe one thing that it's maybe to take into account is that code of conduct are very much suitable for the B2B. And sometimes for us, it's not immediate to the fact that we need to consult the data subject just because we're B2B. So maybe that's also needs to be taken into account that certain codes work on a different relationship than the one directly with the data subject. So maybe the survey with the individuals probably, for us at least, was not relevant at this point in time.
I guess one point you brought up is expectation management. You talked about the number of meetings we've had in this specific code, and maybe the expectations is that it will deliver an endorsed code more quickly than it's taken. So it's having that patience to take it to the level of submitting it to the DPA's European Data Protection Board, which is tough. Which brings me on to really the crucial role of the monitoring body. Because it's not enough
just add before a small thing here. I think one reason why it took also so many resources was that we actually, while we were writing the code, we had to learn how to write a credible code, because we have to concretize, but at the same time we have to stay somehow flexible to cover the whole market, from an SME perspective to the bigger corporations, but also to foster innovation for the future. So we had to develop real methods to write down binding requirements, and concretize, but at the same time now bind all companies to the same process, because there might be a week later a process that is even more effective to reach that goal. So I think we did pretty well, but it took us some time to figure out how to do it right. Yeah,
we're not there yet, but we are.
I think we are.
But
not quite.
But to be honest, it's a process. It's a process also for us. When you start doing this the first time, as it is for the DPA, it is a process, so it takes time. So
before we move on to monitoring, would you, with regard to... Sorry, Maria, yes.
Oh, I'm sorry. If I may add something, I think we have this general approach in the GDPR, and we are facing those kind of problems in some other sectors, and we always provide guidance, and we provide some criteria in many fields with the EDPB, and we develop the criteria, and we apply the law, and we enforce the law, and so we learn from that process. And I think, in some years we all be much smarter about it, much keener about it, because we have those experience we need right now, or we develop right now. So it's I think it's not just a question for the code of conduct. It's just GDPR is really young, and it has just to get into action and to be enforced and to be applied.
And hopefully, with all the work that's gone into this, these tools are future-proof with the right governance, with the right monitoring mechanism. So I do want to touch on the crucial role, and I'll come back to you, but just the crucial role of the monitoring body, and how this is working, and why the monitoring body is it has such an important role in the process of making a code of conduct effective? And I'll ask you.
Should I start with telling why I am important, or? Okay.
Yeah, and I'll start with you, then move over to Marie-Thérèse.
I mean, it's clear, first of all, it's a legal requirement, so it's mandatory to have a monitoring, but at the same time, it's also important from a perspective to make the code work in practice, because if you do that wrong, the costs for actually maintaining to run the code and go into operations might be too high or not really work. So, I mean, I can tell a lot about monitoring, how to ensure independence. Peter Shah helped us a bit to figure that out and how to ensure expertise. But my experience is the most important element is actually, and that's also why I think the GDPR is written in a very clever way, that you have to look for every single code of conduct and find the right monitoring concept for that code of conduct. Is it more aiming for SMEs? Is it what kind of data is processed? What kind of processes are covered? And for that, you developed a unique monitoring concept. And as you know, for example, for the cloud COC, we went very deep with the monitoring. So we have even whistleblowing systems implemented, and initial checkups are mandatory and so forth. But we are involved in other projects where we think that not so much of the processing is happening internally, and more would come out anyway if it's done wrong. So you can apply different concepts which are also more cost effective. And I think this is a really important thing. And while doing that, of course, you have to always think of the monitoring while already writing the code. Because if you write a provision that is not possible to monitor, because in a way, we as a monitoring body would become someone to interpret the law. That's not what we should do. We should find out if someone stick to the rules of the code of conduct or not. That's it. And this is something that is really important. So I always say you have to think of, and call it monitoring by design. So you have to think of monitoring all the time when you write actually provisions of the code. And that's why I think it's important.
And to you, Marie-Thérèse, can you envisage a code? I mean, you're working on not just this code, there are other codes of conduct. Can you envisage a code of conduct working without monitoring?
No. I mean, for sure, the process of drafting the codes of conducts, the right content, consulting, it's already a very lengthy process, and you have to put a lot of energy in it. But the result is not that you have a code of conduct. The result has to be that this code of conduct is applied. So this is what is really needed. And for that, to ensure that, you need the monitoring as well. So I think you need to get both things right. And what the code of conduct enables is that how the rules are set up now is to address the specific needs of specific sectors, which the GDPR as a whole could never have addressed in detail for everyone. And so this is a great opportunity, but you need to draw up the right code of conduct and to make sure that it's applied.
Yeah, so if the monitoring function isn't convincing, a code is not going to be endorsed.
Yes.
And I think just by way of wrapping up, how do we see the future? How many codes do you think there are going to be in one sector? Do you see competition in sectors between different codes? What's the market going to do? How's the market going to evolve? And this is a wide-ranging question, but codes need to be sustainable. So how do you think the market will evolve in this area? You can start.
Okay. I mean, ideally, when drafting a code of conduct on a specific subject, you would consult broadly with all relevant stakeholders, of course also the data subjects, but it should not be that this industry group is now drafting their own codes of conduct and you have two competitors on the same market providing same services or similar services and you have a different code of conduct. That would not be feasible. What I do believe is that the first code of conducts will be the ones which require probably most of the times, also then from the data, from the authority sides to actually know what they expect, what they want, but then others can learn. So I do see that after we see the first ones coming on the market, that there will be more because they see the benefits of the code of conduct. I don't yet see competition between the code of conducts on the same market. I think this is not the tool for competition. That is not the purpose of the code of conduct. my...
Yeah, so last, combine that with any concluding remarks. So you've had your concluding remark, but Peter, we start with you.
Only one sentence. I think that it will be essential which code of conduct will be approved first.
Yeah.
And this will a kind of, not really blueprint, but it will be the criteria whether other COCs will meet the requirements. And therefore, I hope we can get good code of conduct, a good first one, and perhaps it's one that was prepared by you or others. I don't know exactly who will be the first, but I think you are ahead today.
Thank you, Peter. For Maria, any closing comments from your side?
I think I would say the same. So it really depends on the first proceedings, on what criteria we get out of that, what kind of best practices we can develop, and but I'm optimistic that we will have a development from where we are now.
Yeah, we're the trailblazers then, aren't we, Lorena?
Yeah, so we're very optimistic, right?
We have to be.
It's a good final word.
Yeah, no, yes, and I love your expression, we're on the brink, because that's how it feels, we're nearly there. So with that, I'd like to thank the panelists. We're absolutely on time, within seconds. So I'd like to thank the audience for being with us, and any questions we will deal with afterwards. The panel's been too big to open it up to the floor, but we will take questions following this through the organisers. So thank you very much.